For today's closing session. May we please have a round of applause for our speakers for today. On behalf, everybody may please be seated and may please put their mobile phones on silent. On behalf of the Honorable Supreme Court of India, Honorable High Court of Delhi, and the Delhi International Arbitration Center, I once again extend a very warm welcome to all the distinguished dignitaries, delegates, and invitees as we near the end of what has been a remarkable second edition of the Delhi Arbitration Weekend. I would like to take a moment to thank all of you who've taken out your time on a Sunday and being present here. I welcome Honorable Justice Sanjiv Khanna, our chief guest for today's closing session. I welcome Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, and our guest of honor for today's closing session. I also welcome Honorable Justice Manmohan, Acting Chief Justice, High Court of Delhi. I welcome Mr. R. Venkataramani, Learned Attorney General for India. I welcome Honorable Justice Vibhu, Chairperson, DISC, and other esteemed Honorable Judges of the Honorable High Court gracing this session today. I welcome former Judges of the Honorable High Court and the Supreme Court, of the Honorable Supreme Court and the High Court, other judicial members, senior advocates, members of the bar, and all of you ladies and gentlemen. It has been an honor and a privilege to witness the insightful discussions, engaging presentations, and thought-provoking deliberations that hopefully have ensured that all of us have got considerable food for thought and are leaving with valuable takeaways from this weekend. The collective energy and enthusiasm in this auditorium over the course of the last few days have been truly inspiring and portend that arbitration jurisprudence and practice in India will reach even greater heights with the support of all the stakeholders present here. We have saved some of the best for the last, and to that end, our topic and our stellar panel of speakers for this session. Our topic for this session is building a safe arbitral seat, harmonizing national interests and international expectations. On this note, I humbly request Mr. R. Venkataramani, our Learned Attorney General for India, to address this august gathering and give with his special address and enrich us with his valuable insights. May we have a round of applause, please.
Greetings to the learned minds assembled here today, maybe tirelessly after days of deep engagements. Concluding sessions are usually stock-taking events, as flashes of thoughts would have happened already. The congregation may still wait beyond eons to pick up some adventurous or rhetorical or even attempts at restatements, if you may say so, dressed in linguistic archery. I do not propose to do them. But a few statements. The birth of the Indian arbitration bar is overdue. I suppose this weekend can write its birth certificate. As Attorney General, my task is onerous. In the presence of the Honorable Minister for Law and Justice, I must remain within my domain, but kindling his thoughts, though. He is, however, very generous and would not mind a bit of my encroachment. Some preliminary statements. The arbitration slate today is more or less fully written. Its algorithms are spread in almost all spaces of trade, commerce, and other exchanges, both private and governmental. What is noticed is the lack of evenness in its spread. Before I address this subject, I wish to draw a matrix. The pre-1996 arbitration law was an appendage to the mainstream litigation It did not have an independent life of its own, nor was it designed to be a facilitator of new modes of dispute resolution. It did, however, as we moved into a liberalized economy, generate debates on its relevance and utility. The global motions and arbitration regimes, India's adoption of universal norms and principles is now a good story falling in line with several international developments. But the transition from the old order to the new order required many adjustments, paradigm shifts, and the evolution of distinct legal practice cultures. I think the transition may be in the last few phases. I consider cross-border deliberations and engagements from plurality of experiences and perspectives such as this arbitration weekend hugely valuable to facilitate what I call the completion of transitions. I do not propose to revisit the stimulating discussions of the week. I have tried to gather them from most primary and secondary sources who engage in the deliberations, and then I notice that the dialogues demonstrate that we are in the collective process of making and witnessing transitions. Maybe there is a need for a broader free and mutually beneficial borrowings and not unidirectional. Global trade relations and wealth production and resources exchanges are beginning to wear new apparels. Equality of relationships alongside fairness in transactions do inform such exchanges. The lessons we have learned from the dictations and rigidity of GATT and negotiations at WTO and the well-intentioned objection from what is called the Global South countries are lessons to be kept in mind. From contract formation to execution details are now processed through multi-layer legal processes. Ease of business means expedition and least discretionary interventions. Intergovernmental trade transactions are not only voluminous, but encounter several global common concerns such as sustainability. Contract formations in many of these areas, including dispute resolution provisions, are also in the process of transitions. The sheer volume and flow of international transactions and the subtlest of distinctions in the execution of transactions seem to kindle our attention for changes. But these are not beyond human grasp and management. The issue, however, will be the promotion of equal and non-discriminatory treatments. Thus, it is we find that the dispute resolution process in these domains cannot be in isolation from the rest of the transaction and come in a disconnected way. It may be worthwhile if contract formations, including treaty instruments, chart new and flexible formulation for dispute resolutions. Let us call all of this the pharmacopoeia of arbitration at the third round of legal norm settlement. I think it's however important to keep in mind the distinction between reforms and refinements. Refinements are systems' internal practice engagements. Maybe in relation to enhancing the acceptability standards of our arbitral law, India can usher in a few changes in the scheme of court interventions and institutionalizing many features. A recent report submitted by the committee appointed by the central government has addressed some of them, and the government may well do by going ahead with some of the recommendations, and some reforms can also lay down good grounds for refinements. Much is being written about the eastward shift in international dispute resolution. In this regard, the happening of the event in India has relevance in more than one sense, but more importantly, as it serves a platform for one, knowledge sharing, two, emergence, evolution, and equal distribution of centers of excellence. Three, discussions and deliberation on features that are matters of disquiet, namely bias of arbitrators, judicial interventions, and enforcement snares. All of these are mixtures of reforms and refinements. And finally, India, unlike Australia, does not have the problem of what has been called the tyranny of distance. Few pieces of literature on the subject in relation to the Asia-Pacific region are revealing, and particularly on the culture of international arbitration. I wish to quote from one such piece. I quote, "International arbitration superiority and innocence is no greater than a function of particular arbitrators who sit in judgment of particular cases involving diverse parties from the world," unquote. The culture of legal flamboyance developed by international arbitration need not be the measuring yardstick, as one author says. The term localization may be referred here. The term localization was first used by Japanese scholars in sociological reviews and was later defined by Roland Robertson as the simultaneity, the co-presence of both universalizing and particularizing tendencies and the tempering effects of local conditions and global pressures, probably vice versa. We've heard a lot of institutionalizing of arbitral systems. We have seen concerned exchanges on arbitral lapses, bias, accountability, and some procedural distortions. We also heard about the long winding, if I may use a strong word, judicial interventions, though at the discretion of losing parties. These are course corrections which can happen if the transitions are wisely engineered. I do not propose to have a list of do's and don'ts. The India International Arbitration Center is poised to make leaps. It only needs huge governmental nods in favor of its creative motions. I've been talking about a New Delhi convention as the next platform for drawing up the next generation of intercontinental arbitration norms. I wish we can collectively vote in its favor, and I'm sure that the government of India will also stand by this. Let us move in the direction of setting up an Asia-Pacific arbitration roundtable or standing conference to begin with and commence our journey with a handbook on what needs to be done to effect a marriage between domestic concerns and international outlooks. As I understand, India is in a fast-track mode. Its international transactions, modes, and projection show that flexibility is built into them. India can therefore position itself as another equal opportunity and equal partnership platform for dispute resolutions. The world needs not just centers of competition, but partners in promotion of expedition, accountability, knowledge sharing, and best practices. I repeat that we just don't need centers of competition, but partners in promotion of expedition, accountability, knowledge sharing, and best practices. When I say this, I keep in mind the statement made about the culture of international arbitration. All of these, I understand, are as transitions which will not stop. Congratulate the collective genius of the Delhi High Court and the Supreme Court in conceiving this meet, in getting the creamy layers of the bar and the bench. And I once again wish to convey my warm greeting to the wonderful congregation by enriching the deliberation. Thank you for your attention.
Thank you so much, sir, for the stimulating address and setting the tone and context for the session ahead, and also for a bright future for India ahead in arbitration. Our next speaker needs no introduction to most arbitration practitioners. I would like to request Mr. V.K. Rajah, SC and Arbitrator and Mediator, Duxton Hill Chambers, to share his international experience on this issue. May we have a round of applause, please?
The Honorable Minister of Law, Justice Khanna, Attorney General, Justice Bakhru. It gives me great pleasure to be here again this year to address the audience. Join me in taking a journey into the future. The year is 2040. The Indian International Arbitration Center is regarded as one of the leading, if not the leading, international center for arbitration. Indian counsel, Indian arbitrators are highly sought after, not just by Indian clients, but certainly in Asia and possibly globally. Think about it, it's entirely possible. Look at the leaders in technology today, in the US, in Europe. ethnicity is no bar. In fact, it may even be an advantage. And in finance, Indians have shown thought leadership as well as hold senior positions in the top banks globally. Now, is this a mirage or is this a reality? The only reality I can say is that I won't be in arbitration in 2040. Some of us would have retired, but will hopefully be alive and observing with keen interest the progress that has been made with India. I listened with great interest to what the Attorney General has said, a man who's both erudite and a wonderful human being. And I was pleased to note the ambition that he has, that India has, to be regarded as among the foremost thought leaders in arbitration space globally. And that should be what your ambition is. But look at the reality today. I'm going to caption my speech, some hard truths about Indian arbitration. And it comes from the right place, from a friend who wants to see India succeed. For a long time, until I would say the past decade, and the move towards acceptance of international norms came from the Supreme Court, when the Bhatia decision was reversed by Anacon in 2012. And then soon after, you had the Vedanta decision. And that placed India on the right path towards mainstream jurisprudence. Today, the judgments of your Supreme Court are widely regarded and widely read. They sometimes get it wrong, as I mentioned yesterday. The stamp duty case was one, but to their credit, it was quickly corrected. Justice Roy, who's here today, who was in the minority judgment, was vindicated by a majority chaired by the Chief Justice of India. So the mechanisms for correction are there and they're immediate. But that's not enough. If you look at the position globally, historically, there were three main centers. And may I just pause? When I hear observations that the ambition is to make India a global hub, I think that is perhaps an incorrect aspiration. There's no country which is a global hub or global center. It's a city. So you have to choose which city is going to be the center for thought leadership. Is it going to be Delhi? Is it going to be Mumbai? Is it going to be Hyderabad or Bangalore? Or, I know there are many other cities competing, or is it going to be a combination? You could have a global hub and regional hubs. And that's a decision that Indians have to make for themselves, and they're going to have to invest. The decisions you make today are going to have an impact in 2040. Because other than the three main European cities, London, Paris, Geneva, the only other competitor was New York until about 20, 25 years ago. All three are cities with centuries of pedigree behind them, and their colonial past played a role in why they became centers. In the last 20 to 25 years, two Asian cities have become hubs or centers, Singapore and Hong Kong. But how did they get there? It required a whole of country, a whole of government effort, not single centers, not the bar, not the judiciary. They're all important components in this ecosystem. It was a whole of country effort in Singapore, in Hong Kong, to get them to where they are. And this is what is required in India. So you've got two paths ahead of you. Is it going to be a highway with the lights working and no potholes? Or is it going to be a road with potholes, with broken lights, and the picture that I painted at the beginning of my speech, a mirage that is forever receding beyond reach. This future is in your hands. You have what I call, or what I term, the benefit of a demographic dividend. What do I mean by this? India, the arbitration landscape in India, both domestic and especially international, is attracting some of the best Indian minds. It compensates well, the work is interesting, it gives you international mobility. I've met young people from all over the world, and I'm particularly impressed by some of the young people I've met in India and in China. But the advantage the Indians have is language and the common law tradition. And if these younger members, younger professionals are given the opportunity, they're given the exposure, they will flourish. And I am confident they'll take the world by storm and exercise thought leadership. A future president of the ICC could be Indian, the ICA president could be Indian, but again, this should not be based on ethnicity. This should be based on merit. You need to earn your rightful place on merit. But you have a number of extremely able people, not just in their 40s, but also those in occupying senior positions. I've come across Indian counsel in the course of being an arbitrator over the last 6 years, and there are some outstanding advocates. I will just name a few, and I hope you don't mind. Mr. Gopal Subramaniam, who was on the panel earlier, Mr. Gautam Banerjee, Mr. Gora Panchanda, Amit Sibal, to name a few. And you've got many more. They are as good as any of the King Counsel and senior advocates that I've seen elsewhere. And there's no reason why they should not be briefed by just Indian parties. And this is where your ambition should be. The Indian law firms should be looking first at Asia, and then after that, the larger world. Now, but this is not possible. Let me be very direct. Until you get your house in order. And there are 3 areas. There are a number of areas I'd like to address, but time and this platform limits me. But I'd like to address 3 areas. Ethics, education, and the courts. Let's start with ethics. At the moment, many in the legal profession, and some of you have been quite open, feel that when it comes to ad hoc arbitration, there is very many difficult obstacles for accountability. I'm by no means criticizing the fact that in India, unlike any other jurisdiction, ad hoc arbitration is the norm. This is because of historical reasons. But if you don't take steps to change this now, to inject confidence in both the domestic and international arbitration scene, what I described as a possibility will become an impossibility. And the move towards institutional arbitration must be accelerated. How? In Singapore, if we can't change culture, we legislate. We also believe in Singapore, and I'm not saying it applies here, that self-regulation is a myth, because self-interest will take over the prioritization of the common good. So you need to find systems where both arbitrators and counsel are accountable for slovenliness, for inefficiency, and they must be called to book. Those who are not discharging their duties must feel or must be aware that they're accountable to someone, if not necessarily the courts, to the wider arbitral landscape. So you need to devise your mechanisms. You need to find ways to ensure that standards are not just enhanced, but are respected, both within India and outside India. Let me be frank. If Indian lawyers do not believe they have a good system, how do you expect foreign lawyers and foreign parties to come to India either as a place of arbitration or as a seat of arbitration? The first people you need to convince are your own lawyers. And I'm quite sure from the conversations I've had that very many of you feel there's a lot to be done. But don't wait just for the government to come in to step up. The bar associations, the large law firms, you all have a role. Conventions, Delhi Arbitration Week, like this, are a wonderful opportunity, not just to talk about all that's good, but also all that can be improved. You can, I would suggest, at the next session, whether it's next year or in 2 years' time, you have a focus on what ails Indian arbitration. Apply Chatham House rules so that nothing can be reported except anonymously, but the wider public should also know that the arbitration landscape, those involved in the landscape, both arbitrators and counsel, are keen to improve standards and to raise standards. I think that's really important. Let me next move, given the constraints of time, to education. I looked at the speakers. I couldn't see a single Indian academic. Now, as far as I'm aware, my friends here tell me there's no Indian arbitration course at a master's level worthy of its name. Your students, if they want a further postgraduate degree, have to go either to the UK, New York, or Singapore. You have to produce a world-class LLM program, postgraduate program, courses, seminars, to educate aspiring Indians, your younger Indians, those who want to move on to international or even domestic arbitration. You should give them opportunities. Academics should be allowed to also practice as counsel or as arbitrators, because otherwise you're not going to attract the best minds. You need the academics. They're a pillar of any arbitral ecosystem, because the academics are the ones who write, who communicate, and give life to your work, both the judges as well as lawyers. Now, let me very quickly move on to the court system. I completely agree with Justice Rohington yesterday when he said, you need specialist judges. And perhaps he suggested moving on to the divisional court immediately. I would go even further. I suggest you designate the courts in 3 cities, Delhi, Mumbai, and one other place, to be the only places where international arbitral judgments can either be set aside or enforced. And you have specialist judges. But to ensure that there's no monopoly, rotate the judges, train them, expose them, send them for seminars, so that every 3 to 4 years you have changes. And the best will go on to the Supreme Court, where they will make further contributions. So I think the need for specialization, the need for consistent and predictable jurisprudence is critical for India to become not just a safe arbitral seat, but before that, a preferred arbitral seat. Again, this is in your hands. So there's a lot of work to be done. I've only touched on 3 areas. There are several other areas that require to be addressed if India is to become a preferred or leading arbitral seat or place for arbitration. I think it is entirely possible. I've seen the change. I've been a keen student of what's happening in India over 20 years. When I first came as a member of the judiciary trying to sell the SIC and Singapore as a seat. And I remember that we were initially looked at with some degree of reservation, but things have changed. So the critical thing now is for all of you to work collectively together. And I would say, and I want to congratulate Justice Bakhru and his team, this is a good starting point. You should be more ambitious in future editions, you should also have a focus on what's happening in other seats, perhaps start off with Asia, and you'll get a greater international audience. And this international audience, over time, will recognize India for its thought leadership, and I think that's what you should aspire to. On that note, I think I've overstayed my welcome. Thank you very much for your patience.
Thank you so much, sir, for giving such an astute analysis for the topic of the day and offering, as you said, a reality check by a friend of India. Now I humbly request our guest of honor, Honorable Shri Arjun Ram Meghwal, Honorable Minister of State, Ministry of Law and Justice, to deliver the plenary address. May I please have a warm round of applause.
दिल्ली आर्बिट्रेशन वीकेंड, ऐसा कोई प्रोग्राम मुझे रेखा जी ने बताया था। राय साहब हंस रहे हैं ना। तो मैं जब सर्विसेज में था तो मैं देखता था कि लोग वीकेंड के लिए कहीं जाते हैं। तो ये विषय जब मैं यहाँ आया तो ऑनरेबल जस्टिस विभू बखरू साहब ने बताया कि ये तो पूरा 6-7 दिन का कार्यक्रम था। बहुत अच्छा कार्यक्रम मुझे लगा कि ये एक ऐसा सब्जेक्ट है जिस पर आपने चिंतन किया 7 दिन तक। जिसने भी इसमें दिमाग लगा करके इस कार्यक्रम का आयोजन करने का निर्णय लिया, सबसे पहले तो मैं उनको बहुत बहुत बधाई और शुभकामनाएं देता हूँ कि यू हैव चूजन ए वेरी गुड सब्जेक्ट। यू हैव चूजन ए वेरी गुड सब्जेक्ट। मैं कल चीफ जस्टिस ऑफ इंडिया के साथ बीकानेर में था तो मुझे सब्जेक्ट की कोई जानकारी नहीं है जी, और मुझे टिकट भी मिल गई है तो मैं कल से चुनाव प्रचार में भी था। तो मैं आर्बिट्रेटर ढूंढ रहा हूँ कि वो मुझे मदद करे। नहीं, हर क्षेत्र में आर्बिट्रेटर की जरूरत है जी। कहीं 15%, 20% है, कहीं 50% है, कहीं 100% है, लेकिन हर क्षेत्र में आर्बिट्रेटर की जरूरत है। मैं इस अवसर पर मंच पर उपस्थित ऑनरेबल जस्टिस श्री संजीव खन्ना साहब, जो जज सुप्रीम कोर्ट ऑफ इंडिया हैं, उनका भी धन्यवाद करता हूं कि उन्होंने समय निकाल कर इसमें आने की अपनी सहमति दी, तो कुछ उनके विचार भी हमें सुनने को मिलेंगे। ऑनरेबल जस्टिस विभू बखरू जी तो इस काम में लगे हुए ही हैं, और मैंने तो हेमंत जी को भी कहा था कि आप भी थोड़ा इस काम में अपने को तेज़ी दिखानी है, क्योंकि हमने नाम चेंज किया है आपका ऑर्गेनाइजेशन का। बैठे भी हैं हेमंत जी हमारे जज साहब। तो बखरू साहब का भी धन्यवाद करता हूँ जो चेयरमैन हैं, चेयरपर्सन हैं दिल्ली और इंटरनेशनल आर्बिट्रेशन सेंटर के। वेंकटरमणी जी जो अटॉर्नी जनरल ऑफ इंडिया है, वी.के. राजा जो आर्बिट्रेटर और मीडिएटर है, और मनमोहन जी बैठे हैं, 3 जज साहब, और बाकी सुप्रीम कोर्ट के जज भी बैठे हैं, और भी मेरे मित्रगण भी बैठे हैं, लीगल फ्रेटर्निटी का आप सब लोग बैठे हो। मुझे एक चीज़ बताओ कि भगवान कृष्ण क्या थे? मैं आपसे क्वेश्चन करता हूँ एक। लोग हमें कहते हैं कि इंडिया में आर्बिट्रेटर अभी पनपा नहीं, डेवलप्ड नहीं हुआ, ऐसे कहते हैं। कभी कभी मेरे को सुनने को मिलता है कि इंडिया आर्बिट्रेशन का कोई बढ़िया सेंटर नहीं है, और कभी कभी ये भी सुनने को मिलता है कि सेंटर तो बाहर है लेकिन दोनों पार्टियां इंडिया की है, और कभी कभी ये भी सुनने को मिलता है कि दोनों पार्टियां इंडिया की है, वो जज है ना वो भी इंडिया की है, तो वो वहां बैठ के निर्णय कर रहे हैं, यहाँ क्यों नहीं करे? ये भी एक विषय है। लेकिन मैं वहां से शुरू करता हूं, लॉर्ड कृष्णा से। लॉर्ड कृष्णा क्या थे साहब? वो आर्बिट्रेटर या मीडिएटर थे या नहीं थे? बताओ मेरे को। जब आपके पांडव और कौरव लड़ने लगे तो भगवान कृष्ण तो आर्बिट्रेटर के रूप में ही गए थे ना उनके पास, या नहीं? अरे बोलो तो सही कुछ, गए भगवान कृष्ण को भूल गए क्या? वो मुझे लगता है इस संसार के सबसे बड़े आर्बिट्रेटर थे, नटखट भी थे सर, वो अलग विषय है। लेकिन आर्बिट्रेटर की बात जब कोई नहीं मानता है तब या तो सुप्रीम कोर्ट में जाता है आदमी या फिर युद्ध होता है, दोनों में से एक चीज होती है। लोग कहते हैं क्यों सुप्रीम कोर्ट में आते हैं? अभी मैं बैठे बैठे सुन रहा था राजा साहब की बात, इन्होंने 3 चीजें बहुत अच्छी कही कि आर्बिट्रेशन सेंटर या आर्बिट्रेशन के सिस्टम को अच्छा करने के लिए इथिक्स चाहिए, प्रॉपर एजुकेशन चाहिए और कोर्ट सिस्टम को भी ठीक करना चाहिए। तीनों चीजें इन्होंने कही। अब मैं एक बार इथिक्स को लेता हूं आपके। अब इथिक्स को हमें इंडिया को या भारत के लोगों को कोई और समझाएगा? मैं चाणक्य का उदाहरण देता हूं आपको। चाणक्य एक बार काम कर रहे थे और चाणक्य बड़ा नाम है साहब, हमारे भारतीय विद्वान गणों में अगर नाम लेते हैं तो चाणक्य बड़ा नाम है, छोटा नाम नहीं है। राज्य स्थापना से लेकर के इकोनॉमिक्स की पॉलिसी देने से लेकर के दर्शन देने के लेकर इथिक्स को भी जिंदा करने में, नैतिकता को भी बढ़ाने में चाणक्य बड़ा नाम है। तो एक बार चाइना से कोई विद्वान आया और बोला ये चाणक्य कौन है जिसने इतना बड़ा साम्राज्य खड़ा कर दिया, मैं उससे मिलना चाहता हूं। तो ढूंढते ढूंढते वो चाणक्य के पास चले गए। तो चाणक्य उस समय काम कर रहे थे और उस समय लाइटें तो होती नहीं थी, दीपक जल रहा था। और वो उसने कहा भी आपको यू हैव टू वेट, तो वो उनको इंतजार करना पड़ा। 2 घंटे इंतजार करने के बाद चाणक्य उठ करके एक दीपक जल रहा था, उसको उन्होंने बुझाया और एक दूसरा दीपक जलाया। तो जो विदेशी मेहमान आए हुए थे उनको अजीब लगा कि भी दीपक तो जल ही रहा था, इसको इन्होंने क्यों बुझाया? और ये दूसरा दीपक है ये जलाया। तो वो बात करने तो कुछ और आया, तो उसने पहला क्वेश्चन ये किया कि आपने ये दीपक क्यों बुझाया? पहले मैं ये पूछना चाहता हूं। अब यहां इथिक्स समझा रहा है चाणक्य, एक छोटी सी घटना से क्या इथिक्स का लेवल रहा होगा जी हमारे भारतीय दर्शन में। उन्होंने कहा सर आप जब आए थे तो मैं सरकार का काम कर रहा था, राज का काम कर रहा था, तो वो दीपक भी राज का था, बत्ती भी राज की थी और वो तेल भी राज का था। आपने मुझे कहा मैं पर्सनल टॉक करने आया हूं, तो जब मैं पर्सनल टॉक करने के लिए आपके बीच में आ रहा हूं तो ये जो मैंने दीपक जलाया है वो दीपक भी मेरा है, ये तेल भी मेरा है, बाती भी मेरी है, करिए पर्सनल टॉक आप। ये हमारा इथिक्स का लेवल था जी। क्या लेवल था हमारा इथिक्स का? कहां गड़बड़ हुई हमारी? ये चिंतन करने का भी विषय है। हम एजुकेशन में भी पीछे नहीं थे जी। हमारा एजुकेशन सिस्टम इतना एडवांस था, तभी तो लॉर्ड मैकाले जाकर के ब्रिटिश पार्लियामेंट में कहता है कि इंडियन का एजुकेशन सिस्टम को ही खराब करना पड़ेगा पहले, अगर हमें लंबे समय तक इसको राज करना है इंडिया में। तो हमारा एजुकेशन का सिस्टम भी बहुत बड़ा था। हमारा कोर्ट सिस्टम भी बहुत अच्छा था सर, हमारा कोर्ट सिस्टम भी बहुत अच्छा था, कोई कमी नहीं थी। और हमारे आर्बिट्रेटर भी बढ़िया थे कृष्ण जैसे। लेकिन कौरवों ने बात मानी नहीं, उन्होंने तो बहुत सिंपल आर्बिट्रेटर में आ गया, बोला 5 दे दो, 5 गांव, तो भी नहीं माने। तो फिर महाभारत हुआ। ऐसे ही कई बार हम यहाँ देखते हैं कि NHI में एक हमारे लॉ डिपार्टमेंट में कोई वेट करने के लिए मामला आया कि साहब ये आर्बिट्रेशन का मामला है, इसमें आर्बिट्रेटर इतनी फीस मांग रहे हैं, इसको अपने को क्या आपत्ति है, कर दो। तो बाद में 2-3 महीने बाद मेरे समझ में आया कि ऐसा ही मामला कोई वो सेम ही इशू आया और कोई हमारा हेवी इंडस्ट्री का कोई ऑर्गेनाइजेशन है PSU, वो उससे लड़ रहा था। उसने कहा मुझे भी आर्बिट्रेटर करना साहब, मुझे भी पैसा दे दो और आप वेट कर दो। मैं कह यार तुम भी लड़ रहे हो, ये भी लड़ रहा है, दोनों हमारे PSU है, कोई NHI है, तो ये जो हमारा जो आपस का झगड़ा है उसमें भी आर्बिट्रेटर प्रॉपरली काम नहीं कर रहा है। तो ये भी हमें चिंतन मनन मंथन करने का विषय है। कई बार कहा प्रधानमंत्री जी ने कि भाई सरकार के 2 PSU लड़ रहे हैं, एक कह रहे हैं कि ये डिसीजन ठीक नहीं था, एक कह रहे हैं और फीस भी बढ़ती जा रही है, हीरिंग पर हीरिंग के पैसे भी बढ़ते जा रहे हैं। हमारे लॉ डिपार्टमेंट बीच में आता है, वो कह रहा जी नहीं जी आप इसको नहीं, इस वकील को पास नहीं करोगे, इतनी फीस नहीं दोगे तो हम केस हार जाएंगे। कितना कॉम्प्लिकेशन का सिस्टम बना हुआ है जी। तो इसमें मैं समझता हूं कि ये जो ODR का प्लेटफॉर्म है इसको हमें यूज करना चाहिए। ये ऑनलाइन जो डिस्प्यूट रेजोल्यूशन का मैकेनिज्म है इसको हमें बढ़ाना चाहिए। ऐसी परिस्थितियों में मेरा ऐसा मानना है। आपने 7 दिन तक काम किया होगा और शॉर्ट एनालिसिस भी की होगी, उसमें बहुत से आपके पॉइंट भी निकले होंगे। मैं एक विषय आपको देना चाहता हूं क्योंकि ये विषय थोड़ा टेक्निकल भी है, कॉम्प्लिकेटेड भी है। जब हम इंडस्ट्री 1.0 में थे, क्योंकि अधिकतर ईज ऑफ लिविंग और ईज ऑफ डूइंग बिजनेस से संबंधित ही है सारा, ये आर्बिट्रेशन, मीडिएशन, इसकी काउंसिल, उससे संबंधित ही सारे विषय। जब इंडस्ट्री 1.0 में थे हम, और इंडस्ट्री 1.0 कब आया? जब हमारे संसार में स्टीम का आविष्कार हुआ। उससे पहले तो किसी ने कहा ही नहीं कि कोई इंडस्ट्रियल रिवोल्यूशन भी हुआ क्या। लेकिन जैसे स्टीम आया तो हमारे नीतिकार, रणनीतिकार, हमारे प्लानर, थिंक टैंक के लोगों ने कहा इट इज ए इंडस्ट्रियल रिवोल्यूशन 1.0, और वो 100 साल चला। उसी में ये डिस्प्यूट बढ़े, उसी में आर्बिट्रेशन का, मीडिएशन का काम भी बढ़ा। लेकिन फिर इंडस्ट्रियल रिवोल्यूशन 2.0 आया। वो कब आया? जब हमारे सिस्टम में इलेक्ट्रिसिटी आई। तो उन्होंने, इतिहासकारों ने कहा कि अब हमारा ये जो एरा है वो इंडस्ट्रियल रिवोल्यूशन 2.0 का है। और उसने बहुत चेंज किया हमारे इलेक्ट्रिसिटी के सिस्टम ने, प्रोडक्शन को भी चेंज किया, चोरियां भी बढ़ी और हमारे सिस्टम को भी डिस्टर्ब किया, अच्छा भी किया। लेकिन आर्बिट्रेशन का काम भी बढ़ा, कोर्ट का भी काम बढ़ा। लेकिन उसके बाद और एक सिस्टम आया जिसको हम इंडस्ट्रियल रिवोल्यूशन, इंडस्ट्री 3.0 कहते हैं। वो तब आया जब इंफॉर्मेशन टेक्नोलॉजी का जमाना आया। लेकिन हम आज जिस युग में प्रवेश कर गए हैं वो इंडस्ट्रियल 4.0 है। और ये जो प्रत्येक युग है वो 100 साल का है। हमारा स्टीम वाला 100 साल चला, फिर बिजली वाला 100 साल चला, इलेक्ट्रिसिटी वाला, फिर इंफॉर्मेशन टेक्नोलॉजी वाला 100 साल चला। अब ये जो इंडस्ट्रियल रिवोल्यूशन 4.0 है, जिसको हम आर्टिफिशियल इंटेलिजेंस कहते हैं, जिसको हम रोबोटिक्स कहते हैं, जिसको हम IoT कहते हैं, जिसको हम ब्लॉकचेन टेक्नोलॉजी कहते हैं, जिसको हम साइबर ऑफेंस कहते हैं, साइबर फ्रॉड कहते हैं, ये सब उसके पार्ट हैं। और इसमें हम रुक नहीं सकते, ये आगे बढ़ेंगे। हम स्टीम में भी रुके नहीं। लोगों ने कहा स्टीम आएगा बेरोजगारी बढ़ेगी, नहीं, रुके नहीं। मानव सभ्यता स्टीम में आई और ट्रेड बढ़ा, एक दूसरे देशों को जानने का अवसर जल्दी मिला। हम बिजली में भी रुके नहीं, ऑटोमाइजेशन हुआ, प्रोडक्शन बढ़ा, सभ्यताएं विकसित हुई। उसके कुछ फायदे भी है, कुछ नुकसान भी हैं। लेकिन हम IT में भी रुके नहीं। लोगों ने उस समय भी कईयों ने जिक्र किया था कि अगर इंफॉर्मेशन टेक्नोलॉजी में सब काम कंप्यूटर करेगा तो आदमी क्या करेगा। लेकिन आज हम सोचो कि अगर इंफॉर्मेशन टेक्नोलॉजी का युग नहीं आता तो हम घर बैठे रेलवे का रिजर्वेशन करा सकते थे क्या? ये ट्रेन कब पहुंची, कब पहुंचने वाली है, कहां पहुंचेगी, कौन से प्लेटफॉर्म पे पहुंचेगी, ये सूचना मिल सकती थी क्या? तो इंफॉर्मेशन टेक्नोलॉजी का युग हमने जिया, एंजॉय भी किया। अब हम जो इंडस्ट्री 4.0 के युग में प्रवेश कर गए हैं, जिसमें ये मैंने सारे आपके सब्जेक्ट बताए, आर्टिफिशियल इंटेलिजेंस से लेकर के ये सारे सिस्टम में, कोर्ट सिस्टम हो, चाहे हमारा आर्बिट्रेशन का सिस्टम हो, चाहे हमारे मीडिएशन काउंसिल का सिस्टम हो, चाहे मीडिएटर का सिस्टम हो, चाहे एडवोकेट का सिस्टम हो, इसमें ये चीजें काम आएगी ही। और हमें टेक्नोलॉजी का साथ लेकर के इस दिशा में आगे बढ़ना ही पड़ेगा। अंततः हमारा लाभार्थी होना चाहिए हमारा सिटीजन। अंततः सारे सिस्टम का लाभार्थी होना चाहिए हमारा सिटीजन, हमारा नागरिक। और वो हमारे ध्येय में अगर रहेगा कि हमें ईज ऑफ लिविंग और हमें ईज ऑफ डूइंग बिजनेस बढ़ाना है, तो मुझे लगता है कि जो आपने ये काम हाथ में लिया है, दिल्ली आर्बिट्रेशन क्या बोलते हैं सर, वीकेंड ही बोलते हैं ना, दिल्ली आर्बिट्रेशन वीकेंड, ये सफल निश्चित रूप से हुआ है, क्योंकि मैंने सुना इसके बारे में काफ़ी है। ऑनरेबल सीजीआई साहब कल बीकानेर में भी इस प्रोग्राम की तारीफ कर रहे थे। इसका मतलब दिल्ली में प्रोग्राम हो रहा था, तारीफ बीकानेर में हो रही थी, भारत पाकिस्तान सीमा पे। मेरा बीकानेर कोई यहाँ नहीं है, बहुत दूर है भारत पाकिस्तान सीमा पे। तो वो शायद इनॉग्रल फंक्शन में आए होंगे, क्यों ऐसा ही है रेखा जी, इनॉग्रल फंक्शन में आए थे। तो इसकी खुशबू बहुत तेजी से फैली है, और ये खुशबू बहुत आगे चल करके चिंतन मनन मंथन करते हुए अमृत निकाले। इस अमृत काल में ऐसी शुभकामनाएं देता हुआ मेरी वाणी को विराम देता हूं। बहुत बहुत धन्यवाद।
Thank you so much, sir, for your views. And you've, in a very unique way, brought home the fact that arbitration has always had a rich tradition in India and in our mythology. I would now humbly request our Chief Guest, Honorable Mr. Justice Sanjiv Khanna, Judge, Supreme Court of India, to address us and enlighten us on this topic. Please have him.
How do I? Okay. Mr. Arjun Ram Meghwal ji, the Ministry of State, Ministry of Law and Justice, Mr. Justice Vibhu Bakhru, Mr. R. Venkataramani, Mr. V.K. Rajah, retired and sitting judges, members of the legal community and students. Namaste and good afternoon. I'll begin with a preface, not dialectico to the topic, because in the end I have to connect the preface with my conclusion. Trans-border disputes are often involved examination of two aspects: law selection and forum selection, that is the territorial jurisdiction of the court or the forum. Adjudication is not an end by itself. The object and purpose of adjudication is to secure a just and a fair decision by a procedure which is free from influence of external elements. An important facet of justice is the existence of rules that provide a right to fair and just decision, a procedure which gives an equal and a fair opportunity of winning against your opponent. This apart, there are four standard elements. 1, clarity and certainty of procedure and substantive law that govern the dispute. 2, the process should be efficient and cost effective. 3, the decision or outcome should be recognized and enforceable in a country of the opponent. This is mandatory and required as far as trans-border disputes are concerned. And 4, the procedure for enforcement or execution should be quick and easy. The conventional form of dispute resolution between private parties is court litigation or adjudication. This form of dispute resolution in trans-border disputes suffers and falters on the above parameters for several reasons. Apart from the issue of forum or law selection, the parties, due to their nationalities being different, are unwilling or reluctant to submit or refer their disputes to domestic courts of the other parties. There is an element of distrust with respect to foreign courts due to inherent bias or undue preference of parties from the same nationalities. Recognition and enforcement of foreign judgments is governed by the statutory law of the country where the party wants to enforce and execute the judgment. In the absence of any treaty or understanding with the reciprocating country, it requires domestication action. The Hague Convention or the Brussels regime, which govern enforcement of judgments rendered by one nation in another nation, have not gained universal acceptance. This is not so with regard to international awards governed by the New York Convention. The problems of recognition and enforcement of foreign court judgment is substantially addressed by the New York Convention. First, by accepting arbitration in international disputes as an alternative dispute resolution mechanism. Secondly, international awards covered by the New York Convention have an element of recognition and are enforceable in third countries, including the country in which the losing party is a resident or has assets. The New York Convention has gained substantial recognition with 172 signatories. However, as in case of court adjudication, an outside party is usually reluctant to accept arbitration and its outcomes and feel it may not be a just and a fair procedure. The reasons are most the same as court adjudication, like unfamiliar foreign laws, language, and systems. Questions of fairness, bias, and prejudice of the adjudicator are also raised. Affiliation or invisible bias among arbitrators is a challenge which is required to be addressed. Affiliation bias has been defined as cognitive predisposition to favor a party due to cause of appointment. It is not just restricted to appointment or nomination bias. In case of transnational disputes, it is broader and wider. There is empirical data supporting existence of implicit biases in a variety of settings. These can arise from sympathetic attitudes towards a specific group or certain beliefs. In case of affiliation bias, arbitrators, despite their best intention, remain biased and are primed to favor one litigating party. One of the challenges faced in international arbitration is practice of double hatting, where individuals act simultaneously as arbitrators and legal counsels in different cases. Performing multiple and sometimes overlapping roles can affect arbitrators' ability to act impartially and might hint towards impropriety. Double hatting also reflects lack of diversity, slower disposal of cases, and raises issues like elitism by thereby eroding public confidence. Double hatting is also closely connected with the repetitive appointment of arbitrators, wherein same arbitrators are appointed to hear multiple cases involving the same parties or related issues. While such appointments are driven by specialization and experience in the relevant field, it also creates a perception of bias, as arbitrators may be seen to favoring one party over the other based on their previous decisions. Repetitive appointments or double hatting results in lack of new or independent judgment and in fact forecloses their door for new and competent arbitrators. High cost of arbitration, arbitration, even in institutionalized and international arbitration, is a drawback which of late has been noticed and commented upon. The prevailing sentiment that administrative charges of an institution, arbitration costs, expert witnesses constitute majority of the financial outlay of the parties. Third-party funding in litigation and arbitration financing is also a matter of concern. The last aspect is soft laws, which refer to non-binding rules, guidelines, and principles that are developed by international organizations, arbitral institutions, and other stakeholders in international commercial arbitration. Soft laws are intended to provide guidance and best practices to both parties and arbitrators on issues such as arbitrators' ethics, procedural fairness, and conduct of parties. However, there are several apprehensions which cannot be overlooked. These might arise on account of lack of clarity, consistency, and limited accountability. Further, presence of several soft law frameworks might lead to overlapping, conflicting, and thereby resulting in the dilution of effectiveness and potential abuse. What is seat of arbitration and its importance to international arbitration and domestic arbitration? The significance of seat of arbitration has been often highlighted across many decades of jurisprudence surrounding arbitration law. It is a core aspect of arbitration insofar as designation of a seat determines the courts which will have exclusive supervisory jurisdiction over the arbitration proceedings. That apart, the seat plays a crucial role, especially in international commercial arbitration, as the procedure for arbitration is normally regulated by the seat of arbitration, also referred to as lex arbitrii. Redfern and Hunter have encapsulated the importance of seat in arbitration as follows. The place or the seat of the arbitration is not merely a matter of geography. It is a territorial link between arbitration itself and the law of the place in which the arbitration is legally situated. The seat of arbitration is thus often intended to be the legal center of gravity. This view expressed by Redfern and Hunter was applied in Bharat Aluminium Company, thereafter again by this court in BSG Soma joint venture, wherein it has been held. The concept of judicial seat of arbitration proceedings and its relationship to the jurisdiction of the court, which are then looked into by matters relating to arbitration proceedings, including challenges to the arbitration was unclear and had to be developed in accordance with international practice on case-to-case basis by this court. Whenever there is an express designation of a venue and no designation of an alternate place as seat, combined with the supranational body of rules governing the arbitration and no other significant contrary indica, the conclusion is that the stated venue is actually the judicial seat of arbitration proceedings. Coming back to the practical aspect of choosing a seat, given its significance, it is advisable for the parties to themselves choose a suitable place of arbitration rather than leave it to choice of others. Herein, the question also arises when there is one dominating party or one party which is economically stronger. They normally then enforce the place of their choice as a seat of arbitration. But then there is another way of looking at it. Business entities logically prefer a stable, expected, and safe place in order to commercially contract and invest. While significant aspect of this atmosphere is decided by economic policies and economic status of the markets at the time, but there is a significant aspect of this atmosphere which would be legal dispute resolution place and efficiency thereof. And this is where the parties act choosing the seat of arbitration becomes pertinent. They look for seats which possibly are partial, if not neutral, with a robust arbitration framework, convenient enforcement mechanisms, in other words, safe seat of arbitration. This brings us to the next question: how to build a safe arbitral seat while accounting for domestic realities. It is almost as if we are revisiting an often debated topic. An annual stable in arbitration conferences in India. Is India a desirable seat of arbitration? And to see India in its trajectory as being preferred seat in international arbitration. How does a jurisdiction build a safe arbitral seat? There can be no straitjacket formula. Of course, there are certain aspects which are crucial in terms of the impact they have in the terms in which seat is perceived by the users. The three aspects which are important are: one, robust legislative framework and practice surrounding arbitration; two, arbitration-friendly and pragmatic approach by the judiciary; three, convenient enforcement mechanism. I believe that the aspect of robust legislative framework and practice surrounding arbitration is an aspect which India must take into consideration if it wants to become the preferred seat of arbitration. It is imperative that the next focus of India as a whole in its arbitration journey should remain mindful of its domestic arbitration landscape while making constant push to meet international standards and keep up with the developments in the global arbitration. There are three main issues which arise. I'm sorry, I forgot about my PPT. If you look at it, these are grounds relating to international arbitration which normally arise. These are substantive law governing the contract, procedural law governing the arbitration proceedings. The law governing the arbitration agreement pertains to its existence, validity, interpretation. Law governing capacity of the parties to arbitrate. Law governing the line of enforcement of the award. Unfamiliar foreign laws, language and systems. Affiliation bias amongst arbitrators. Cognitive predisposition in favor of a litigating party. Double hatting, individuals acting simultaneously as arbitrators and legal counsels in different cases. Overlapping roles can affect arbitrators' ability to act impartially. The second slide, which is there, is with specific regard to consideration and challenges in arbitration, international arbitrations. These are third-party funding, which is, we are not fully aware, but it is happening abroad fairly constantly. Repeat appointment of arbitrators, soft law and non-binding rules to provide guidance, high cost of arbitration, incapacity or invalidity of arbitration agreements due to due process irregularity, excess of competence to jurisdiction, public policy consideration. Limited scope, when I refer to, depends upon the public policy of the nation states, because several disputes cannot be referred to in arbitration. Like in India, we don't allow people to refer disputes relating to competition law to arbitration, whereas in some countries, competition law disputes can be referred to arbitration. Difference in nationality, cultural norms, accepted practices, conventions, element of distrust in foreign arbitrators' forums, including inherent bias in favor of the domestic party. The three main issues which are arising in India which require attention are: A, need for good, independent and impartial arbitrators; B, preference of ad hoc arbitration over institutional arbitration which requires correction; and C, high costs and delay in arbitration proceedings. In its evolution, the legislature and the courts have made successful attempts to allay the deficiency in the arbitration process in India. We have adopted the model law, which in fact has elevated the state of India to potentially a safe seat for arbitration. This was further cemented by 2015 and 2019 amendments. However, institutional arbitration has not been, as promised under the 2019 amendment, been implemented. To what extent these amendments have been successful is an aspect which needs to be debated openly and clearly amongst the government, amongst the arbitrators, amongst the judiciary, as well as the stakeholders, that is, the litigants. I had come across one 2013 survey. Normally, we believe that we have good, competent, fearless arbitrators. 2013 survey by one of the big fours I'm not going to name that big four, mentions that arbitration proceedings are critically affected due to lack of availability of large pool of arbitrators with regard to industry knowledge and necessary professional attitude. I do not know whether that report is biased or not, but if it is circulated and it has been put in the public domain, it's a matter of concern, and we must confront it with adequate data and details. There are plenty of, on the second aspect of ad hoc arbitrations, I refer to the data, but there's plenty to suggest that ad hoc arbitration is norm, and even in ad hoc arbitrations, timelines suffer due to no overseeing of the arbitral process by an institute and multiple applications, petitions being preferred by the parties. I was a member of the chairperson of the Delhi High Court International Arbitration Center. Invariably, I'll receive requests that the arbitrators are saying we will not conduct the arbitration on the aegis of this institute, but are outside. That was a matter of concern which I raised, and I clearly said that should not be permitted. The ad hoc first mindset among the domestic users at the flush bus does indicate preference for adopting ad hoc arbitration. However, on closer analysis, it would show that it also persists due to shortcomings in the process that has somehow left the door unlocked for court intervention and or abuse of the process by the parties and even arbitrators. Of course, the courts have made it aptly clear that they will strictly, now coming to the third aspect, which is the court interference, I think over the years we have now very clearly stated that the courts will interfere when absolutely necessary. And this approach has been adopted and applied across the board. The legislature too has been proactive in bringing changes in the law to make it sync with international standards and further attempted to introduce concepts such as Arbitration Council of India, which unfortunately is still to be modified and be effective. Now I'll come to some data with regard to what is happening, what are the problems being faced. The World Bank data notes that enforcement of contracts in India take about 1,445 days at the cost of 31% of the claim. In comparison, the average duration in South Asian countries is 1,101 days, which is almost 2/3 of the time taken in India. When it comes to OECD countries, the time taken is 589 days, which is 1/3 of the time taken in India. It's a matter of concern for all of us. This has to be rectified and checked. When it comes to the data with regard to number of cases being referred to institutionalized arbitration, the picture is again very bleak. In 2023, about 1,16,453 civil cases were instituted in civil courts in Delhi, while 4,243 suits were instituted in the Delhi High Court. Today, there are about more than 1 lakh civil suits pending in various courts and district courts, and about 14,660 civil suits pending in Delhi High Court. As against this, in 2023, 7,358 cases were referred to arbitration to the Delhi High Court Arbitration Center. This means Delhi High Court Arbitration Center dealt with only 6 to 7% of the matters referred compared to the civil litigation. I agree, possibly the matters referred to ad hoc arbitration will be 2 times this amount. This is a matter of concern. Arbitration is not the first choice of any litigant in India. Otherwise, everybody, when they come to the court, will move an application or joint applications, please refer our disputes to arbitration. It has very rarely happened. I do not think, in my tenure as a judge of the Delhi High Court, I had ever received an application in a civil matter saying the parties want the matter to be referred to arbitration while it was pending in the court. So the fact of the matter is, parties prefer court litigation and adjudication to arbitration. The next slide will show the advantages of arbitration proceedings. These are avoids technical rules of procedure and evidence and gives flexibility, results in binding dispute resolution with limited grounds to challenge. It allows the parties to choose their adjudicator. It gives choice to the specialists and technical experts as adjudicators who can appreciate and understand the technical issues and therefore promote practical decisions. It cuts delays, costs, and does not involve any court fee. It gives choice with regard to venue, scheduling, timings of hearing to suit convenience of the parties. It provides a non-hostile atmosphere, making the parties and witnesses comfortable and conducive to settlement. But the next slide is going to cause a little flutter. What are the disadvantages of the arbitration proceedings? I will not like to read them, but you can please go through them. I'll stop here for a minute to enable you to read them. Now I'll come to the solution part. How do we deal with this problem? In the United States, 68% of the commercial cases under the American Arbitration Association are concluded in settlements. In the Financial Industry Regulatory Authority of USA, 83% settlement rate is reported, 57 through direct negotiations, and 12% through mediator-assisted resolutions. Similar is the position in the United Kingdom, where civil and commercial mediation has grown to about 12,000 cases annually, an increase of 20% since 2015. Data from Singapore Mediation Center shows mediations have resulted in 84% participants saving costs and more than 88% experiencing respite from undue delays. Now, how do we go from here? We have to now corroborate and introduce mediation into arbitration. Do we have those trained mediators who will be able to do that? That's the issue which we'll have to address and go into. The UN General Assembly also endorsed amendments in 2002 to model conciliation law by introducing unicentral model mediation law and United Nations Convention on International Settlement Agreement through mediation, commonly known as the Singapore Convention. It is noted by jurists that interplay between Singapore Convention and model law parties will have direct ability to invoke international settlements and agreements as both sword and a shield. Why do I say so? I like to quote from Mahatma Gandhi what he had said. Truly a person is indurate and acts cowardly when they resort to the court of law. Surely a decision of a third party is not always right. We in our simplicity imagine that a stranger, by taking our money, gives us justice. It is in this background that a less formal alternate dispute resolution method, mediation, has gained recognition as less adversarial and more corroborative approach into dispute resolution. I've taken a lot of time. I can go on for another 10 minutes, but I'll cut short that. I feel we have to now evolve a system and jurisprudence in Delhi International Arbitration Center by merging mediation and arbitration to ensure that the parties do not lose their right to decide for themselves. How do we do it? We cannot have the same person acting as a mediator and the arbitrator. It has to be two separate persons. That is what the unicentral model also recommends. We have to evolve and get into all this in case we have to look 10 years ahead and want India to be the preferred seat for arbitration. We can do it. It is possible. Only thing is we have to now focus on it and execute it. Thank you so much, and Jai Hind.
Thank you, sir, for offering those very valuable insights on how to build India as a safe arbitral seat and for shining light on some of the challenges facing us and maybe showing MedArb as the way forward. I would now call upon Honorable Justice Vibhu Bakhru, Judge, High Court of Delhi and Chairperson, Delhi International Arbitration Center, to give the vote of thanks to our eminent and distinguished dignitaries, delegates, and invitees. May we please have a round of applause.
Justice Khanna, Justice Roy, Meghwalji, the Honorable Minister of Law and Justice, Mr. Venkataramani, the Attorney General for India, Justice Manmohan, our patron, the Acting Chief Justice of the Delhi High Court, Mr. Rajah, Justice Karnik from the Bombay High Court, my brother and sister judges who are present here, Mr. Chetan Sharma, the learned Additional Solicitor General, dignitaries of the dais, ladies and gentlemen, a very warm good afternoon to all of you. We have now come to the conclusion of the second edition of DAW. It stands for Delhi Arbitration Weekend, but as you know, it spanned over 5 days and 6 if you count the external events, which were pre-DAW events. It should
possibly now be called Delhi Arbitration Week instead of a weekend. At the outset, Justice Manmohan had drawn a simile of a 5-day cricket event, the Test cricket match, with this event. And he had said this is going to be a grueling but an intense format, and it truly was. I truly also hope that the participants have found it stimulating. I, on behalf of the Delhi International Arbitration Center and the Delhi High Court, express our gratitude to our patron, the Chief Justice of India, Dr. D.Y. Chandrachud, who extended unreserved support and spearheaded the Supreme Court's collaboration for hosting this event. We owe a debt of gratitude to Justice Khanna, our Chief Justice, for sparing his valuable time to address this closing session of DAW. He has presented a very comprehensive and a scholarly overview of the subject at hand. And sir, we will assure you that we will incorporate mediation with arbitration in the Delhi International Arbitration Center as suggested by you. Our special thanks to Justice Rishikesh Roy, Justice M.M. Sundaresh, Justice Maheshwari, Justice Vikramnath, Justice Anirudh Bose, judges of the Supreme Court who, despite their packed schedule, spared their valuable time to chair the technical sessions and guided the discussions. We are truly grateful to Meghwalji, the Honorable Minister of Law and Justice, and our guest of honor this afternoon for sharing his views and further inspiring us to draw inspiration from our rich cultural heritage. Thank you, sir. We are also truly grateful to Mr. Venkataramani, the Attorney General of India for India and the leader of the bar, for sparing his valuable time on this Sunday forenoon. Our special thanks to Mr. V.K. Rajah, truly a thought leader in this field, who has traveled all the way from Singapore and has shared his insights with all of us. We are also truly grateful to Justice Manmohan, our patron, the Acting Chief Justice of Delhi High Court, who has supported holding of this event in every possible way. We are also grateful to Justice Rao, Chief Justice of the Himachal Pradesh High Court, Justice Sunita Agarwal, Chief Justice of the High Court of Gujarat, who, despite their time constraints, traveled to Delhi to participate in this event. We are also grateful to Justice Ramamurthy, Justice Dangre, Justice Bhanot, and Justice Karnik, who have traveled from different parts of India to join this event. In addition, I'd also like to mention our gratitude to Justice Uday Lalit, former Chief Justice of India, Justice Sikri, Justice Nageshwar Rao, Justice V. Ramasubramaniam, Justice B.N. Shri Krishna, Justice Rohinton, former judges of the Supreme Court, who guided various sessions at DAW. I also express my thanks to Mr. Tushar Mehta, the Solicitor General of India, for sharing his insights on challenges involving the arbitrations involving state-owned entities. This event has had full support of various members of the judiciary: Justice Hima Kohli, Justice Vishwanathan, Justice Amanullah, Justice Ujjwal Boyan. Judges of the Supreme Court spared their valuable time and participated in the external events, making them more enriching for all participants. I'm also thankful to my colleagues from the Delhi High Court, Justice Jalan, Justice Jasmeet Singh, and Justice Ganju, who also participated in the external events held in the calendar of DAW. We also express our thanks to Mr. S.P. Chenoy, Mr. Vijay Narayan, Mr. C.A. Sundaram, Mr. Gopal Subramaniam, for sharing their views and participating in these discussions. Last but not the least, we are also truly grateful for working committees, members of the working committees, the executive committee, the program committee, the protocol team, the research publication team, the logistic team, the hospitality team, the venue management team, the social media and publicity team, the external events team, the session coordinators and compares, a team of over 100 persons who worked tirelessly over the past few weeks to ensure that this edition of DAW is a success. Each one of the team members contributed more than their call of duty. For them, it has been truly a labor of love. To all the participants from all across the world who have joined us in this event, I truly hope that this edition of DAW has been a pleasant and enriching experience. I thank you all for participating in this event. Thank you and good afternoon once again.
Thank you, sir. I now request Honorable Justice Manmohan, Acting Chief Justice, Delhi High Court, to facilitate our distinguished speakers with a small token of our respect and gratitude. May we please have a round of applause and may we please continue with the same. So we definitely need to thank you. This is the moon. May we just have a token. We now come to the end of the second edition of the Delhi Arbitration Weekend. I would like to thank the honorable guests, both on and off the dais, for taking their valuable time to attend this event. It has been our pleasure hosting you. We would like to conclude the weekend with the national anthem. I request all of you to please stand for the national anthem. That brings us to an end. I now request all of you to join us for lunch.